When a couple goes to court for a divorce, what do you think happens? Well, you'd probably assume the whole point is to end the marriage, right? But what if I told you that in India, under certain laws, the court's very first mandatory duty is actually to try and save it? Yeah, you heard that right. This isn't just a nice idea. It's a surprising legal obligation that we're about to unpack. So, here's our roadmap. We're going to look at what this final chance in court really is. We'll dive into the specific laws, see when this rule gets skipped, unpack a really interesting legal debate, check out how it all works in practice, and finally tackle a huge question. Is the law's job to fix broken marriages, or just to help manage the fallout? All right, first things first, let's get right to the heart of this pretty counterintuitive idea. I mean, it sounds a little backward, doesn't it? You've got a couple that has already reached the point of taking legal action, and yet the system is designed to, hit the pause button. But the answer, in a whole lot of cases, is a resounding yes. This whole process is called reconciliation, and the key word here, the one you really got to remember, is mandatory. This isn't a judge just giving some friendly advice. Nope, it's a legal requirement, a duty that's actually placed on the court to make every possible effort to bring the couple back together before the divorce can even move forward. So, where does this really powerful duty come from? Well, it's not just some old judicial philosophy, it's written directly into the law books. You'll find this obligation spelled out, clear as day, in two of India's most important matrimonial statutes, the Hindu Marriage Act and the Special Marriage Act. Both of them have sections that are almost identical, and they put this responsibility squarely on the court's shoulders. And here's the key takeaway. The law doesn't give the court a choice in the matter. It says the court shall make this endeavor. So while there might be some wiggle room on how they do it, the duty to at least try is absolute. It's a foundational step in the whole process for these kinds of cases. Okay, but does this apply to every single divorce case, no exceptions? Not quite. The law is smart enough to know that in some situations, trying to get a couple back together is just not going to work. The law basically carves out these really specific grounds for divorce, where trying to reconcile would be impractical, or honestly, even cruel. For example, if we're talking about incurable insanity, or if a spouse has been missing for 7 whole years, or has converted to a different religion, the law sees the very foundation of the marriage as, well, irrevocably broken. In those cases, reconciliation efforts would just be futile. Now, this is where a really fascinating legal debate pops up, because even with a clear rule, judges in high courts haven't always seen eye to eye on one critical point: which court actually has to do this? The law uses this phrase. It says the court must make an attempt in the first instance. But what does that really mean? Does it mean only the very first court that hears the case, the trial court, or does it mean at the first available opportunity, even in higher courts that are hearing an appeal? And this is where you can see that conflict in action. The Mysore High Court took first instance very literally. They basically said the duty is only with the trial court, and that's it. But the Allahabad High Court had a much broader take. They argued that since the whole goal is to save the marriage, any court, even an appellate court, should make the effort. And these days, legal thinking tends to lean more towards the Allahabad view, prioritizing that chance to reconcile at any stage of the game. So we've covered the what, the why, and the when. Let's get down to the how. What does the actual machinery for this process look like? The court has a pretty specific toolkit. First, it can just pause the case, adjourn the proceedings. Second, it can refer the couple to a trusted, neutral third party. Maybe it's someone they both name, or maybe it's someone the court nominates. This gets them into a more informal space away from the courtroom. And finally, that person has to report back to the court and say whether or not a reconciliation was possible. And the law is surprisingly specific about the timing. It says this adjournment for reconciliation shouldn't be for more than 15 days. So it's meant to be a focused, short attempt, not some indefinite delay that just drags the case on forever. This quote from the Calcutta High Court just hits the nail on the head. It perfectly captures the spirit of the law. The court's job is to open a door, not to force anyone to walk through it. If one person is just not willing, like the wife, Aloka, was in this case, the court can't compel them. It's an endeavor, not a command. Okay, let's pull back and look at the bigger picture for a second. This whole process raises a really fundamental question about what the law should even be trying to do when a marriage is on the rocks. To put the Indian approach into perspective, it's really helpful to see what's happened in other places. In England, for instance, they found that by the time a case actually gets to court, the marriage is often beyond saving. So they've shifted their focus away from reconciliation to something a little different: conciliation. And this is where you see the huge difference in what they're trying to achieve. Reconciliation, in the Indian context, is all about restoring the marriage, getting the couple back together. Conciliation, on the other hand, basically accepts that the marriage is over. Its goal is to make the separation as smooth and painless as possible by helping the couple agree on all the practical stuff like money and the kids. And that brings us right back to the fundamental question at the heart of all this. Is the proper role of the court to be a marriage counselor, making one last attempt to mend the union? Or should it be more of a pragmatic mediator, focused on just helping two people uncouple with dignity? The Indian law, for now, has its answer, but it's definitely a question worth thinking about.